You may 2 minutes.
Once you have Mr. Yuvraj P. Narvankar, an advocate from Bombay High Court, who is also an author, you are quite sure that though he's young, but his knowledge is which matches up with any good professional. And we have been taking sessions with him which have other practical aspects we can see rather than the bookish knowledge. Taking cue from that, the today's session is on documentary evidence in courtroom. The topic itself explains that the today's journey would be in respect of as to how this documentary evidence in the courtroom is tendered and appreciated, etc. And today we have also made a special request to him that at the end of the session, he will summarize the session in Hindi as well as Marathi. So it's a different topic. And I was just talking to him that in one of the sessions, we had requested Justice Oak on his book on electronic evidence. And somebody has actually just pitched in that kindly bring Justice Oka someday. We have already done one session with him on the book launch of Mr. Yuvraj, so that memories are giving us the moist feeling of that. I will not take much time. Over to you, Yuvraj. We know that you have a bad throat, but your passion to pay back to the society is a different. And one caveat, Mr. Yuvraj has told that there is rain. So probably, though we don't expect that the session may go because of the bad weather, but inshallah, so theek hai. Over to you, Yuvraj.
Okay, thank you so much, Vikashji. I hope I am audible and clear. As Vikashji has put in the caveat for me, thank you so much, because it's really raining very heavily here, torrential rains, and we just had the nets back in the late afternoon. But as he said, everything should go fine. I'm very happy to be back at Beyond Law. It's always a pleasure to be here. As he rightly said, today's session is going to be very practical. I would not make it a very long session. The session would be time-wise very short. What I will be focusing, the session will be in 3 parts. The first part will be, we will be talking of documentary evidence under the new Bharatiya Sakshi Adhiniyam. How is the documentary evidence treated under the Bharatiya Sakshi Adhiniyam? उसके बाद हम चर्चा करेंगे about some practical tools that I personally use in my own courtroom trials and arbitrations, which I hope will be very handy for the practitioners. They are not trade secrets, but if used well, they can very well be a trade secret. But I don't mind obviously sharing that with you if it serves your purpose. And third and last portion, as Vikashji said, we will have a short summary, so to say, in Marathi and Hindi. So let's begin. Let's straight away dive in. Bharatiya Sakshi Adhiniyam, and this will be not more than 12 minutes, the first part, because we will be just recapping what Bharatiya Sakshi Adhiniyam has got for us. So, talking of a documentary evidence, Bharatiya Sakshi Adhiniyam has not changed. More or less it's same, except the electronic evidence. And I have already given my talk on the electronic evidence on this very channel, Beyond Law, just few days back. So today I will not be talking of electronic evidence, though it warrants some mention, maybe that I'll do in a minute or two. But my primary focus today will be proving, disproving, marking, exhibiting, discovery, inspection of the documents, and there are certain nitty-gritties involved. With the help of the Supreme Court judgments, we will try to unearth a few things which will be useful in the practice. The first section that would be very important for us will be section 2 of the new Bharatiya Sakshi Adhiniyam. And that's nothing but the definition clause. Now, definition clause, as you know, is something that has been put in. Earlier, it was really the interpretation clause. Now, please see, those of you who have got the new act, please have a look at the first very section is the applicability, on which we will not really talk much. Please come to section 2 and look at the definition of the word document. Document means anything inscribed on any substance by any means. The definition is very easy. So suppose if I take this paper, I write anything on this, it may be a paper, it may be any substance, it may be a skin, it may be anything, it may be even a CD and DVD, this will still be a document. So that's the definition of the document for you. Nothing really much. Straight away, let's today go to Chapter 4 and Chapter 5 of the Bharatiya Sakshi Adhiniyam, that's of some relevance to us. Section 54 of Bharatiya Sakshi Adhiniyam, if I'm not wrong, is old section 59 of Indian Evidence Act, which talks of the oral evidence. Now, what's oral evidence? As you would all know, oral evidence is something that is given by the witnesses when they step into the witness box. The Evidence Act is very clear that says that anything can be proved by oral evidence except the contents of a document. So please mind this, and we will today start from the basics and we will go on advanced level. Let me start from the scratch. I won't detain you on the basics for a long, but let's begin the basics. The documents has two parts, existence and the contents. Existence means this paper itself, and contents mane whatever is written in the documents, in that particular document. Section 54 tells me that you can prove any fact, but you cannot prove the contents of the document by oral evidence. Now, this is very important for a reason that oral evidence otherwise is permissible in all the respects, but except the contents of a document. Then how do you prove the contents of the document? The contents of the document can be proved by primary and secondary evidence. And that's what section 56 gives me, that contents of a document may be proved by primary and secondary evidence. What is primary evidence? The document itself produced for the inspection of the court is called primary evidence. Suppose it's a sale deed. Getting the original copy of the sale deed to the court is called the primary evidence, as simple as that. Getting a Xerox copy to the court is a secondary evidence. Right? We will not again detain ourselves on this for long. Only one thing you please note. Look at section 57. 57 has not changed. Primary evidence would mean the document itself produced for the inspection of the court. But please look at the explanations below. Earlier, there were just 3 explanations. Now you will find there are 7 explanations. Those added explanations relate to electronic evidence. And as I have already said, I have spoken at length on the electronic evidence, but please have a look at yourself. So far as the paper documents are concerned, there is no change. And I'll take all the questions at the end. And please reserve your questions, and we will have all the question answers. We will have a question answer session at length. So 57 is very important. Primary evidence has not changed. It remains the way it is. What is secondary evidence? Now it's little interesting. Section 58 has been changed. What is secondary evidence? A certified copy is a secondary evidence. Copies made from the original by mechanical process like a Xerox machine is a secondary evidence. Copies made from or compared with the original is secondary evidence. Oral accounts of a document is a secondary evidence. And now 2 categories have been added. Oral admission and written admission is a secondary evidence. And the last category that has been added is the evidence of a person who has examined the document is a secondary evidence. What do we mean by this? Suppose I want to adduce an evidence, a huge balance sheet. It is impossible for any person to go threadbare through the balance sheet. So what I do, I appoint a chartered accountant who will go through the balance sheet and he will tell the court what it is about. Now, his evidence will be a secondary evidence under this newly added subsection Roman 8, evidence of a person well versed with the examination of the lengthy documents. This is secondary evidence. Then the section tells me that the contents of the document must be proved by primary evidence except in the cases hereinafter provided, and that section 60 tells me which are those cases in which I can give the secondary evidence. Now, I would not, again, as I said, you can read the section for yourself. I will not reiterate the section, but mota moti the category is that when the original is in possession and power of the defendant or the other side, you can lead the secondary evidence. If it is in the possession of someone who is not subject to the process of the court, you can lead the secondary evidence. If the original is not easily movable, like let's say a server of a computer system, not easily movable, lead secondary evidence. Original is lost and destroyed, you can go ahead. So these are the situations in which you can lead secondary evidence. You can read the categories yourself, nothing really great about it. And not much has changed there as well. Now, rest of the sections, except one section, are all pertaining to the electronic evidence. And as I said, I will not really bother you today much on the electronic evidence. So what we seen, we saw the definition of document. We saw that it must be proved not by the oral evidence, but only by the documentary evidence. Then we saw what is a primary evidence, the document itself. Then we saw what's a secondary evidence. And then we saw in what cases a secondary evidence of any document can be given. Now let me take you to the second part, as I said, and there are obviously then there are categories of documents. There is a public document under section 74. Public document is any document which is kept in the public records. It may be FIR, it may be a registered copy of a sale deal, it may be records of some official bodies like the government maps. It can be anything which is kept in the office of the government or the public authority. That's a public document. And then there is a certified copy section, which I think is section 76. Now, as I said, let me today begin by showing you what I use personally in some of the arbitrations I do, which is a norm in international arbitrations, but I have not seen it being used effectively in the domestic courts. And I strongly believe that if we use it, particularly my junior friends, if you use it, it will be of immense help. So before I show you that on the screen, let me tell you two tricks. Whenever you are approached with any suit or any case, always start with the end. It may be a writ petition, it may be a suit, it may be any simple application, always start with the end. What do I mean by this? And I'll explain this to you. Suppose a client comes to you with the case that an agreement that the defendant executed with him, he is not ready to abide by that and he wants it to be enforced. Naturally, it will be a suit for a specific performance. Correct. Now, you will have to ask for a decree of a specific performance. Never ask the client what does he have to prove his claim. Start with what would you need for a successful decree or the judgment in a suit for a specific performance. What will you need? Let's take an example. You will need a concluded contract. It may be oral, it may be written. If it's written, you will need the original, you will need the primary. What else will you need? You may need, under the old Act, Specific Relief Act before 2018 amendment, you had to plead readiness and willingness. Now you don't need to plead, but you need to prove readiness and willingness. So you need to prove readiness and willingness. Second factor you will need. Third factor, you will also need to show the correspondence between the parties. So you have now end in your mind that suppose I need 1, 2, 3 factors to succeed in this suit for a specific performance. Or take a suit for a partition, you need to establish a nucleus, you need to establish your right to seek partition, all that. You need to show absence of any previous partition. Once you have this end in your mind, now you ask the client what has he got. Now, when you make this list of what you require, please don't sit without the bare act. Please don't sit, and this is really for my junior friends. And I have immensely benefited by this methodic approach. Look at the bare act, look at the section, look at the substantive law, look at the procedural law, and then write down yourself, this is my Mount Everest summit. Once you define your summit, then you will have to find your way above on the mountain. And therefore, start with the end. Take a case of a writ petition in the Bombay High Court or in any High Court, a writ of a mandamus. What will you need on a documentary front, on a documentary evidence? When I say documentary evidence, I always don't mean suit. It may be even a writ petition on the appellate side. For a writ of mandamus, I need to establish my legal right. What's my legal right? I need to establish that I asked for the legal right. So my requisition to the government. I need to then show that my right has been refused, it has been negated, it has been denied. So that denial is very important. So I have 3 important documents I will require as a foundation for my petition. Suppose I have this list ready that this is what I want. Now go backwards and start from the scratch asking the client, what have you got? And here now let me share with you what a schedule I have made, which helps me immensely when I go for a trial, when I go for a writ petition. I'm just sharing the screen, Vikashji. Is it shared?
Initially, it had popped up, but now it's not coming.
I'm sorry.
Initially, it had popped up, but now it's not coming.
Oh, okay. Okay. Just give me a minute. Is it now?
Yeah.
Okay. Let me first show you what is called as a red font schedule. I'll just maximize the window. Just give me a minute. Can you see something on the side on the screen? Now this is called as a red font schedule we often use in the international arbitrations. This is from a matter which is no longer a sub judice matter. It's from arbitration where government of Canada was one of the party. I'll adapt this to the Indian courts. That's what I have done, but I need to show you what it looks like. Those of you who are interested can take a snapshot, or it's freely available. First is the category, which is a documents or category of documents requested. Second is a relevance, materiality, reference to the submissions, reasons for a request, a reference to submissions, exhibits. Third is a column, reasoned objections to the documents production request. Then is a column, response to the objection, and finally is a verdict of a tribunal. Now, how does it really help us in our trial? I'll just show you that in a minute when I'll tell you the adaptation I have done of this to the Indian courts. Just give me a minute. Yeah. First is a serial number you will see and the relevance. Please study this table carefully, and in the light of this, we will study CPC and we will study BSA. I am going backwards today. Document and relevance. Please look at the bottom. One is a category of the documents I must have. Second is a category is a document which you should have. And third is you may have, won't really matter for the suit. Document and relevance grade. So please see, in a suit for a specific performance, agreement to sell is a document which I have. So I have given it number 1. It is must. Subject matter agreement. Now, do I have an original or a copy? Client says, sir, I have original. Very good, write original. Then आप client को पूछोगे, ये sir कौन prove करेगा? Mr. Singh has signed it. He is a vendor or is a vendee. The client who has come to you must be a vendee, probably. So Mr. Singh is going to prove it. Fine. Who is available? Is Mr. Singh available? You may say, no, sir, वो तो गुजर गए. His wife is there. So who is available? And reason, Mrs. Singh, because Mr. Singh has died. Fine. Look at the next column. And ये मैं आपको बाद में relevance इसका बताऊंगा why this is very important. Each column has got some legal history. Averment in pleading. Mr. Singh has died on so and so date. Mrs. Singh can identify his signature. Is a pleading you need to make in a suit. Averment in the affidavit of evidence that you will find under Order 18 of CPC in lieu of the examination in chief. वहां पे भी आप you will mention that similar details like when Mr. Singh died and how Mrs. Singh, sorry for the typo there, when Mrs. Singh witnessed his signing the other documents, why is she able to identify Mr. Singh's signature? You will elaborate that in the affidavit of evidence. Cross-examination is a matter of the future. Keep that blank. I'll tell you how does it really help you. Suppose, assume for a minute, there is a question on Mrs. Singh's ability or her statement that she had seen Mr. Singh signing a document. And I, as a cross-examiner, asks the lady that, is it correct that Mr. Singh never carried to his home any of his official work? To which the lady says, yes, it's right. Is it also correct that you never had an occasion to visit his office? That's also right. So I am doubting the veracity of her statement when she says I can identify his signature. So these kind of questions will find mention in this column, which will impinge on the correctness of what you have said in the plaint and the affidavit. Let's keep that aside for a minute. Now something very important. Look at this column. Status and the reason. Now you make a color code. Now this may be red, maybe anything that you want. I make that with a pen. Why I have put that red? Suppose if you feel as a lawyer that while in the course of a trial, I will face some kind of legal trouble, you put it as a red. And don't turn it into a green unless the trouble is completely gone, unless you have done the troubleshooting. Now, why it's red? The reason is deficit stamp duty. My agreement to sale talks of a possession, making it a conveyance under Article 25, let's assume, of the Maharashtra Stamp Act. It would now need the full stamp duty, whatever 3-5% with the cess, whatever it has. But it doesn't have that. So deficit stamp duty. So what will hit me? Section 34-35 of the Maharashtra Stamp Act or a Stamp Act. A document with a deficit stamp duty cannot be read into evidence. That's why that red is there. A red. Then what action do I propose? Look at the last column. I'll keep ready the impounding application. That I will file the application for impounding as and when the stage comes. Now, why the red is important, I'll tell you. We, as a lawyer, my friends will agree, deal with so many cases on any given day that it is very easy to forget something very basic, unless reality hits you hard when you are in the final arguments. My junior friends may not really find this very difficult because I have been through that stage when अपने को ऐसा लगता है कि नहीं, this won't happen. Case मेरे पास इतना ही है कि आप रात को भी मेरे को जगाओगे, I can rattle what is important. No, this is not about you are having fewer cases or too many cases. This is about a discipline. If you make this into a habit, take it from me, you will face minimum casualties. Whatever happens in the law, you can't help it. Whatever the judge does it, you can't help it. But the negligence is no excuse, and this is the biggest antidote to the negligence. Unless that red is staring at you, don't go for a final argument. Because you don't mark it red, you come across the cases where during final arguments, you move amendment application. Then judge says, sorry, you are late, mister. Order 617 has a proviso after trial, you can't move amendment. Then you move impounding application. He says, sorry, the cross is over. Now you can't move impounding application. I want to now produce a document, my lords. Sorry, you need to produce it along with the plaint under order 7 rule 14 and for written statement order 8 rule 1A4. Now the bus is gone. To avoid these belated responses, always look at that red dot. If that red dot is appearing, don't go for a next stage of the suit. Coming to the second document. Letter dated 2nd January 2024, I have marked it grade 1, must document, because it indicates readiness of Mr. Singh. He had written it when he was alive. Let's take it. Right? Now, I don't have the original. I have an office copy. Why? Because obviously the original will be with the other side. So, you remember the secondary evidence? Original is in possession and power of the other party. One of the causes under section 60 of the Bharatiya Sakshya Adhiniyam allows you to produce the secondary evidence when the original is in the possession and power of the other party. Now, is it a secondary document, secondary evidence? Yes. A copy is made from the original by mechanical process is a secondary evidence. So this is fit to go as a secondary evidence. Now, who should prove? Mr. Mehta. Now, he is not Mr. Singh. He is a clerk of Mr. Mehta, Mr. Singh. He is the, let's say, Munim J, who has written that letter on behalf of Mr. Singh. Mr. Mehta is to prove. Who is available? Mr. Mehta is very much alive. He can come to the court. He can do it. Now, in the averment in the pleading, I need to say that letter is signed by Mr. Mehta on the instruction of Mr. Singh. Very crucial. And I'll take you to the judgments of the Supreme Court and the Bombay High Court and other high courts, why this is important. You need to specifically say these are written at the instruction of Mr. Singh. And in the affidavit of evidence, you will have to repeat this, but with many more added details. For example, how Mr. Mehta was employed with Singh, for how long was he working with Mr. Singh, how he used to write all the official correspondences of Mr. Singh. And this is a concept called as an intrinsic evidence, which we will talk about later. So you will have to, as I said today, friends, I'm having it little innovative way. I'm going from backwards. So let me first explain to you. So while I talk about legal position and the case laws, you will have this chart on the back of your mind. So today we are starting from the end. Otherwise, I was planning to show this chart to you at the end after we had a discussion on the law, but I decided to show this at the outset for a reason. Fine. So this is how you will say in the affidavit of evidence. Now look at the status. Status is green. I have a Xerox. I have Mr. Mehta. Everything is hunky-dory. No reason to worry, no action proposed. Friends, you will do this exercise for each and every case that comes your way. You will do this for a writ, you will do this for miscellaneous application, you will do this for a suit, you will do this for a written statement. Does not make any difference which matter you are dealing with. If you do this, it will have tremendous impact on your success. Now, let me start with what, as I had said, with the legal position to support what we just discussed and to tell you how does it really help you in the practical parlance. There is one more thing I wanted to share with you, is that a documentary evidence is something so crucial that you cannot ever leave it for a future stage of a suit. Whenever a client meets you for the first time, your first 3 meetings at least, that's my benchmark, you must devote to the discovery of documents, not from the adversary, but from your clients. I'll tell you why my experience has always been, and that's why you should start with the prayers. My experience has always been the clients always withhold some crucial documents from you, maybe deliberately, maybe inadvertently, but they do that. 99% friends, and that's a very, very, very responsible statement I'm making. 99% of the times the clients have left off one or other document that they give to you when the matter reaches the evidence. और जब वो ऐसी बात बोलेगा क्रॉस में जो उसको मालूम है उसने गलती कर दी, then he will come out with the document. But sir, we have this. If you ask him कि सर आपने कभी भी उनको लेटर ऐसा लिखा था जो आपने बोला था कि आई एम रेडी टू अबाइड बाय माय एग्रीमेंट? हाँ सर लिखा तो था. आई एम टॉकिंग ऑफ अ डॉक्यूमेंट ऑन रिकॉर्ड. रिकॉर्ड पे कोई डॉक्यूमेंट है ऐसा? नहीं सर, रिकॉर्ड पे तो शायद नहीं है. On that day of the admission, he will come to your office with that paper in the hand कि sir, ये आज जो वकील साहब पूछ रहे थे ना लेटर, ये वो. And it will be too late in a day to produce that document. So always do this, that you conduct the preliminary cross examination of a witness before you go for drafting. A preliminary cross examination, because you know in a specific performance what cross questions will be asked. Generally you do the preliminary cross examination. This was just again, as I said, a trick of a trade that you should employ often. Now the document, the structure of the evidence is like this. It is a 3 filtered mechanism, as I have always said. The first filter is called as a filter of relevancy. Any document that you prove must be a relevant document. Now, what is relevancy is explained by the chapter 3 of the Bharatiya Sakshi Adhiniyam, which facts are relevant. Let's not really talk much about it. Second filter is called as an admissibility filter. So this is a glass of a water. This comes through a filter. So first filter is a relevancy. Second is an admissibility. Third filter is called a probative value. And this glass in the water itself is called proved and disproved. Let me explain this to you. Whenever a documentary evidence is proposed to be given to the court, first you will have to talk of the relevancy, which is old section 136 of the Indian Evidence Act and 141 of the Bharatiya Sakshi Adhiniyam. It tells me that whenever evidence is proposed to be produced in a court of law, the judge will ask the party, or judge may ask a party, as to in what manner this evidence will be relevant if I allow this. And the judge shall admit the evidence only if it is relevant. So always remember, the first filter is of a relevance. If your evidence has to pass 3-layered filter, the first filter is of a relevancy. 141 or 136 is a chapter of a relevancy. In the Indian Evidence Act, the filters are arranged chronologically, except one filter that I'll tell you. The first filter, first chapter आपको जो मिलेगा वो है relevancy का chapter. That's for a reason, because it's a first filter. Second filter is of admissibility. Now, what is admissibility? Assume for a minute that it's an agreement to sell. I'm sticking to the same example, so it's easy for you to understand. Agreement to sell, it's a relevant document. It is a relevant document. Deficit stamp duty, is it admissible document? It is not admissible document because deficit stamp duty. So your evidence passed the first filter, but your evidence now cannot pierce the second filter of an admissibility. It will get stuck there. It will get stuck. So second filter. Assume you make an application for impounding, you get it impounded, you pay the stamp duty. It will now pass to the second filter because the signal will turn green on your table. It passes to the second filter. The third filter is of a probative value. What do I mean by the probative value? Now, this is very crucial concept. In the Indian Evidence Act and Bharatiya Sakshya Adhiniyam, you will find these two sections of relevancy and of the admissibility. But third filter you will not find anywhere in the Indian Evidence Act. That's a matter of a judicial appreciation. Probative value means, or a weight of an evidence means, what does the evidence conveys? For example, the agreement to sell passes through the first filter, passes through the second filter. But if you look at the document, it says that the vendor will sell vending a land at, let's assume, Mumbai. No details, nothing, no four boundaries, or no gut number, no survey number, something missing. Now, the probative value of the document or the weight of the evidence, let's call it a weight of evidence, will be so less that despite passing through the first two filters, it will be of no use to you. So technically, this will fall foul of the third filter of the weight of the evidence. It has really got no weight because the property description is as vague as it can ever be. So this is the third filter. And the fourth is called, as I said, proved and disproved. So in the event if the document passes through these three important stages, then the court will apply its judicial mind and will tell you that this is proved or this is not proved or disproved. So always remember, let's have the discussion on the basis of these three filters. Coming back to the topic of the marking of a documents. Now, as you are all aware, the trial passes through many stages. Plain file hoga, written statement file hoga, issues will be framed. And then will be something called as an admission and denial of documents. Jahan pe you will be called upon to admit or deny a document. Now, this admission and denial of documents is the most crucial step that the lawyers always overlook. And they may do it through the junior lawyers, they ignore it, and then the reality hits very hard when the matter is in the final stage. Why do I say it's done very lightly? Because we deny the documents for the sake of a denial. My request to all of you is to never deny a document for the sake of a denial, because in the jest you end up denying many documents that are really helpful to you if you look at the documents. So if it has come from the adversary, I must deny it. So please do away with that notion. Don't deny the document for the sake of the denial. Now, admission and denial, a process will happen after inspection of the document. So suppose it's a sale deed. The sale deed has been filed along with the plaint. You will ask for the inspection of the copy of the sale deed. After you are given inspection, you will be called upon to admit or deny the contents of a document. Under the Commercial Courts Act, please mind this, you cannot have the vague denials. Under the Commercial Courts Act, the law is very clear. There is a judgment of the Delhi High Court on this, which is, I'll give all the citations to you at the end. If you want, I can give it right away. There is a judgment of Windscreen Holdings Private Limited versus Religare Finest Limited, where the Delhi High Court has said that in the commercial matters, please don't deny the documents for the sake of the denial. That's not how it is done. You will have to give the reasons. And please do that even for the ordinary suit, even if it's not a commercial transaction. So that's one part. Second, always remember the judgment of the Bipin Shantilal Panchal of Bombay High Court, which is a milestone judgment, and Hemendra Rasiklal Ghia. I'll share the list of citations with Vikashji at the end of the session. These two judgments tell us that when a document is marked into evidence, it does not mean the document is proved. It only means that the document exists. Now, this is very crucial. I need to pause here for a minute. There are three things of a document, please remember, and I'll give the citations to support this. One is called signing of a document. Second is called execution of a document. Third is called as the truth of the document. What is signing of a document? Or let me call four things: existence, signing, signature, the truth of the contents, and the contents and the truth of the contents. What do you mean by existence of a document? Suppose I give this document in the evidence saying that this is the payment I made to the collector for making my land NA because I wanted to sell this to you. This shows my readiness and willingness to perform my part of contract. Now you must buy this. This is a suit. Wendy said, sorry, I don't know what this document is. Where did it come into existence? I don't know the existence. So you are denying the existence. That's the first category, the existence denied. Second is the contents. Contents means whatever is written in this also will obviously stand denied because you are denying the existence itself, the contents will be denied. Now, please mark the very important difference between signing of a document and execution of a document. This is something very crucial distinction which you will have to remember. Generally, we think that signature means execution. No, please take a judgment of Dr. Chandrachud as the Chief Justice as he then was, Veena Singh versus District Registrar. Veena Singh versus District Registrar. Justice Chandrachud had said that signing merely because, and this is very crucial for my lawyer friends when you are putting your witness in the box, you will write in your affidavit of evidence that this document has been signed by Mr. Mehta. Let's go back to our table, right? Signed by Mr. Mehta. But you do not write anything about the knowledge of that signatory about the contents of a document. And Justice Chandrachud has said that only when the signature is with the knowledge of the contents of a document, then it amounts to execution. Otherwise, the signature is different from the execution. And this is very crucial distinction you must remember, because we generally stop by saying that this document is signed by so and we stop there. No, make an averment, detailed averment about how he does have a knowledge, a personal knowledge of the contents. If you want me to just tell you the relevant para, makes an interesting reading, just 3 lines. It says, the execution of a document does not stand admitted. I'm reading from a judgment. Because a person admits to have signed it, such interpretation accounts for circumstances where individual may sign on a blank paper and later someone fills the document and individual is made to sign the document which is already filled. This does not mean that he has executed, because he does not have any personal knowledge of what is written on the paper. Okay, so this is what the judgment says, that please mind that you will have to essentially set out this in affidavit of evidence. Now, also, as I said, that judgment is very crucial of admission and denial, which is again judgment Burger King Corporation versus Techchand Sevakram. Burger King Corporation versus Techchand Sevakram. I'm just telling you the names. You can Google it, or I'll give the citations. Here, the court has said, Delhi High Court has said on what grounds you can deny a document. What are the legitimate grounds on which you can do that? And the court has set out 7 grounds on which you can deny a document. The court has said you can do it. Unusual format of a document can be one ground to deny the document. Absence of a witness having personal knowledge. Anachronism, information not available when the document came into existence. Lack of reasonable economic background. Forensic traces of forgery, and so on and so forth. So the court has given around instances where you can legitimately deny a document. And the court had said, High Court had said, that please don't deny the document except for these grounds. Otherwise, it will have a cost repercussions. Okay. Now, let me just have a word on the secondary evidence, because this is something very, very crucial and that we will encounter often. A secondary evidence is, you don't require any application for a secondary evidence. This is, I think by now should be very clear. In fact, judgment of, this is very important judgment of Justice Oak, Justice Kaul and Justice Nath. You can have a citation of Harindra Rai versus State of Bihar. It's a 2023, 13 volume, Supreme Court cases 563. 2023, 13 volume, SCC 563. In this case, the Honorable Supreme Court had said that whenever a document is marked into evidence, it does not mean that the contents are proved. It will have to be proved independently, point number 1. Secondly, you don't need to have any application. Please mind the word, any application for leading the secondary evidence. You don't need this. What you need, I'll tell you in a minute. Take the citations. Sheikh Ahmed versus Bhimrao. Sheikh Ahmed versus Bhimrao. In the writ petition number 8442 of 2019, 8442 of 2019, and Dhanpat versus Shevram. These 2 judgments tell me that you don't need to file any application. Instead, what you must have is a foundation in the pleadings for leading the secondary evidence. If you don't have the foundations, Justice Patel in one of the judgment, I'll give you the judgment in a minute. Yes, the judgment is Karthik Bhatt versus Nirmala Wagh. Karthik Bhatt versus Nirmala Wagh, a judgment of November 3rd, 2017. Justice Patel has gone to the length of saying such application is not maintainable. Application for leading secondary evidence is not maintainable. A foundation has to be laid only in the pleadings and the affidavit of evidence, and you straight away file the secondary evidence. You don't need the application. And whether the circumstances really existed for you to file the secondary evidence is a matter of a cross-examination. So, suppose if I'm a plaintiff, I want to lead a secondary evidence, I say that original is in the possession of my opponent. I have given him a notice. He has not produced it. So here is my secondary evidence. Or my original is lost and destroyed. Here is my FIR. Allow me to file the secondary evidence. Whether it is actually lost and destroyed is a matter of a trial. The judge cannot go into that question when the secondary evidence is being taken on record. Because as I said, the principle applies. Exhibiting does not mean the proving of a document. It's only a ministerial act that does not take you any further. It is only for the mark of identification of a document. And this judgment is very important. Simarpal Singh versus Hakam Singh. The ratio is very important. It says, at the time when a petition is filed for producing secondary evidence, nothing more needs to be proved than stating one of the grounds as required under section 65 to justify reception of a secondary evidence. Whether the grounds really exist or not can only be tested in a cross-examination. This is very crucial. Always keep this in mind. That, and therefore, suppose if you have to say that it is lost and destroyed, your affidavit must say ki I have filed my FIR on this and this date because my document was lost or it was stolen. If you make that foundation in an affidavit of evidence, you don't need to do anything further. Now, another question that often comes up, suppose if original agreement to sale is, as I said, deficit stamp duty is tainted by deficit stamp duty. You don't have a copy. So you have a Xerox copy of that original document. The Supreme Court had said that such a copy cannot be impounded. Please mark this. This is very important because for impounding, you have to have the original document in place. You cannot impound the Xerox copy. And such document clearly becomes inadmissible. You have no remedy of any nature to produce that document in the evidence. Second part is very important, which I have always seen people going wrong there, is a certified copy of a document under section 74 of the Indian Evidence Act and the Bharatiya Sakshi Adhikar. There are an empty number of judgments on this of the High Court and the Supreme Court that marking of a certified copy of a document does not mean that the contents of a document are proved. This is very crucial. Suppose if I submit a certified copy of, let's say, a sale deed, maybe a public document, or FIR, maybe a public document, but the Supreme Court and even the judgment of, as I said, Bipin Shantilal Panchal very clearly says a certified copy of a document will have to be proved as any other ordinary document and it deserves no separate treatment. So I will have to prove the contents of a document and I will have to prove the truth of the contents of a document. Now, only for my junior friends, these two lines. What is the difference between contents and the truth of the contents? Suppose if I say that suppose if A calls B an idiot person, an example I always give, B files a suit for a defamation because A called him an idiot person. B files a suit for a defamation in which he submits this email on record to prove his case for a damages. A denies having written any such mail to B. A denies the existence, condition, and contents. B submits this in the record. Now, when B submits the original email or the printout of an email, and he submits that certificate of old 65B or new 63, the document, that email will be marked into evidence. When it will be marked into evidence, what are you essentially proving? You are proving that A indeed wrote that email to B, existence. B, you will prove the contents that A indeed called B an idiot person. You proved the contents. You proved the existence. You proved the contents. Are you proving really truth of the contents? B is not proving the truth of the contents. If he proves the truth of the contents, his suit for the damages will go. So basically, the contents and the existence does not tantamount to the truth of the contents. And this is very crucial in that 4 filter. The 4 filter, you remember the admissibility filter, the relevancy filter, the 3rd filter we spoke of the probative and the weight. The 4th that I spoke of this glass, the proved and the disproved is this. Ultimately, the judge will find out the truth. You cannot prove the truth. You can only give the corroborative evidence. The truth is always decided by a judge. And therefore, what we are today discussing are only the first 3 filters. The 4th filter is a filter of an advocacy, which you will have to really put the metal hard during the final arguments to make the judge believe that what I am saying is the truth. So there, these procedural nitty-gritties will not come to your rescue, but the substantive provisions of law will come to your rescue. So have this always on your mind, that certified copy of a document do not enjoy any higher status. You can take a citation. Ram Reddy versus Land Acquisition Officer. Ram Reddy versus Land Acquisition Officer. The citation is 1995, second volume. 1995, second volume, 2 Supreme Court cases 305. Another judgment you can have is Collector Raigad versus Hari Singh Thakur. It's 1979, first volume SCC. Okay, so this is one, and now let's come to the last part of this. There are 3 kinds of objections you can take to a document. The first is called, or there are 3 categories of objections. The first is called inherently inadmissible documents. Second is called technically inadmissible document. And third is called the waivable category. Let me explain to you. For example, if a document is insufficiently stamped, it's a waivable category. Because if you look at section 3536 of the Stamp Act, it says that if you do not dispute exhibition of a document which is insufficiently stamped, you cannot later raise that challenge. Same is a case of electronic evidence certification. Suppose if you don't file 65B certificate or 63 certificate and the document is marked into evidence. After obviously Arjun Pandit Rao Khotkar, the Supreme Court has said it to be a mandatory. But if you look at the continuous line of judgments, it has been held to be a curable defect. Mind the words curable defect. Deficit stamp duty, curable defect. Submission of a certificate of electronic evidence, curable defect. Fine. So remember this, that these are the curable defects. If you do not raise your objections in time, you lose the bus. And you cannot later be heard to object to a document during appeal or a revision. Second category of a document is called inherently inadmissible document. They mean, for example, it's a communication between me and my client. It's a privileged communication. My objection, though not recorded, the document will still remain inadmissible because that's a privileged communication. I think old 127 or 120 of the Indian Evidence. So these objections can be raised even during the appeal, even during the revision, even during the second appeal, because the document was inherently inadmissible. So always remember that when you're standing in the shoes of the opponent, you should look at the document which is marked into evidence. If it falls into the first category, you kind of lose your case, because then there is no reverse gear. There's judgment of Justice RMS Khandeparkar of Bombay High Court, which says that a document once exhibited cannot be de-exhibited. Very important. Always remember, I have seen some applications being filed. The Supreme Court also had said it in one of the cases. But exhibition is a one-way process. It's a unilateral process. You cannot de-exhibit it. Once it is exhibited, it will be read into evidence. Now, whether the truth and the contents, matter of evidence, but it will be read into evidence. If you do not want a judge to read something into evidence, you have to stand up and object to the document being marked then and there. And therefore, kindly go through the judgment of Bipin Shantilal Panchal. I have always felt that judgment to be the encyclopedia. And Hemendra Rasiklal Ghia, it's a judgment of the full bench of the Bombay High Court, encyclopedia on this. Then, again, there is something I need to tell you about the handwriting. Handwriting experts evidence we used to do under section 45 of the old Indian Evidence Act, the experts evidence and all. The law requires, the Indian Evidence Act and the Bharatiya Saksha Adhiniyam requires us to, if it's a document compulsorily to be attested, one of the attesting witnesses to be examined. But for an handwriting, you can, if the person who has written it himself is not available, you can always summon someone who is well aware of his handwriting. But always remember that's a second stage. The Bharatiya Saksha Adhiniyam allows the judge himself to compare the two signatures and arrive at his own conclusion. So always do not jump on the wagon of the expert evidence. If the judge is not convinced on the similarity, then you may think of adducing the better evidence in the form of an handwriting expert or the person who is acquainted with the handwriting. Please don't jump directly on the expert's evidence, because expert evidence is not binding. One, the judge can very well ignore the expert evidence, and therefore my always advice is to first look at the sections which help you without any external assistance and then go for the external assistance. Another judgment on the end note I'll give you is the Sudhir Engineering judgment versus Nitco Roadways. A very beautifully written judgment of the, I think it's a Delhi High Court again, Sudhir Engineering versus Nitco, NITCO Roadways, where the courts have said that a document passes through the three stages. The court says the first stage is when the documents are filed by the lawyer. Second stage, when the documents are produced into the evidence. And third is called when the documents are proved or not proved. For my junior friends, Order 13.1 and Order 13.234 of CPC are very important. Please have a look at it after the session. A filing is a clerical act that your clerk will do by going to the department. It's just filing. Production into the evidence is an act of exhibiting a document, which is the second stage. And third is a stage when the document is proved and disproved. And Sudhir Engineering beautifully throws light on this. So, as I said, and then there is a separate section on the ancient documents or documents which are more than 30 years old section 90 of the Bharatiya Saksha Adhiniyam. But as I have said, Indian Evidence Act, I have already at length spoken on all these sections in my other webinars. So today my whole attempt was to tell you as to how you should look at the documentary evidence and understand the importance of a documentary evidence, because ultimately what will hit you very hard is not chapter 5 of the documentary evidence. What really will hit you hard is chapter 6 of the Bharatiya Saksha Adhiniyam, which is exclusion of oral evidence by the documentary evidence. You cannot lead any oral evidence to exclude the terms or override the terms of a document. So once the damage is done by not filing the documentary evidence, one last point before I forget. Many a times lawyers try to reserve a document for a cross-examination of a witness. Order 7 Rule 14, Order 8 Rule 1A and Order 13 Rule 3 allows you to do this. And let me explain in a minute. It is necessary under Order 14 that you file, Order 13 that you file all the documents before framing of issues, correct? You have to file the original documents before framing of issues. Order 7 tells you have to file the documents along with the plate. Order 8 tells you have to file all the documents along with your written statement. But there is only one stated exception. Exception is if I want to hold this document back to surprise a witness during the cross-examination, I can do that. क्योंकि अगर मैंने मेरे सारे पत्ते ही खोल दिए, then there will be nothing remain in the trial. So I will hold some document back as a surprise element. Barring this document, you cannot hold on to any document. You have to prove it. You have to put it on the record. Now, a word of caution. Generally, what happens? Suppose if this you hold on to a document and you show it to the witness. Under section old 145, please look at the comparable provision of the new Bharatiya Saksha Adhiniyam 137 read with 145 of the Indian Evidence Act. You can confront a witness with a document to which he is a signatory himself. You cannot confront him with something to which he is not a party or a signatory. Many lawyers commit a mistake by holding on a document with the very innocent hope that मैं जब क्रॉस एग्जामिनेशन का टाइम आएगा आई स्प्रिंग दिस एज अ सरप्राइज विदाउट अंडरस्टैंडिंग कि भाई तू जिसको दिखाने जा रहा है ये डॉक्यूमेंट ही इज नॉट द ऑथर and law does not permit you to confront him with that document. So the liberty that order 7, order 8, order 13 gives you will have to be seen in the context of Indian Evidence Act, what is allowed and what is not. So if you do not propose to call that gentleman as a witness, or if the other side does not have that person on the list of witnesses, don't take the risk of holding back a document. You may lose it. You may not be allowed to put it on record. Now the law is very clear. Please take the citation. Vidyut Sarkar, BIDYUT, Vidyut Sarkar versus Kanchilal Pal. It's a 2024 judgment. You can please Google it. You will get it. I don't have a size too recent to have a citation. Vidyut Sarkar, where the Supreme Court has dealt with very interesting proposition. What the proposition was? एक विटनेस आ गया विटनेस बॉक्स में, मैंने इसको कन्फ्रंट कर दिया कि सर ये डू यू नो दिस, यू जस्ट सेड दैट this is not this way, look at this letter. He said, I don't know about this letter, I have not signed it. Now question arose whether this document should go on record or not. मैंने दिखा तो दिया, now it should go on record, right? If he admits this document, it will go on record, it will be marked into evidence, not a rocket science. What if he refuses the document? The Supreme Court had said it should still go on record, because the judge, while giving a final verdict, should at least know what was shown to the witness. He should at least, there should be an argument part open for a lawyer to indicate the malafides of the witness, to deny that, how his conduct was, how his demeanor was, how despite he having a knowledge of this, he refused it. So the court said you cannot not take the document, you must take the document. And last, impounding applications, impounding cannot happen unless the original is produced. There is a judgment of the Supreme Court of Justice M.R. Shah called widescreen holdings. In widescreen holdings, the Supreme Court had said the judge cannot direct impounding of any document unless it is produced before him. You cannot say कि ये document is important, you impound it and you send it. No, unless it is produced before him, you cannot impound it. Take the citation, which is the last citation of today's session. It's very crucial. I think again an encyclopedic judgment of Roman Catholic Mission versus State of Madras, AIR 1966, Supreme Court, 1457. With this, I would like to conclude. I'll open it for any questions and answers. And as I said, today was not really the time when I wanted to reiterate about the sections. You can read the sections yourself. They are very informative of the new Bharatiya Sakshi Adhiniyam. What you must remember, a last note to the junior lawyers, please go through the section. For example, possession and power, we just spoke of, section 60. Don't just read the section, understand its applicability to your case, and always make a checklist. I would advise strongly reading a book called as a Checklist Manifesto by an author called as Atul Gawande. A beautiful book. It's in a different context, but I always feel the lawyers must have it. Atul Gawande's book. You know what he had said? He had said that airline is an industry which has the minimum accidents. You know why? Because the pilot, even if he has a 10,000 hours of flight experience, they have a checklist. So whenever you go to the flight early, you look at the cockpit, you turn left and you look at the cockpit. They would be always writing something on a sheet. What is it? It's a checklist. Even if the pilot has got 10,000 hours of experience, he will fill up that checklist. What is the checklist? He will have to write up the cargo size, cargo weight, the right spoiler movement, the fuselage weight. He will make that checklist. As a lawyer, you must always also prepare a checklist for the suits that often come your way. आपको मालूम है आपके पास कौन सा काम आता है? आपको 3 साल में पता चल जाता है कि मेरे पास फ्रीक्वेंटली कौन से पैटर्न का काम आ रहा है. Is it very difficult for you to make a checklist? कि मेरे को अगर स्पेसिफिक रिलीफ का काम आ रहा है और पार्टीशन का काम आ रहा है और मेरे पास रिट का आ रहा है. दिस इज माई चेकलिस्ट. पार्टी टिक, पार्टी सब है. पार्टीशन में ऑल ब्रदर्स एंड सिस्टर्स टिक. Subject matter, all parties, all properties included, tick. Because if you don't include all the properties, if you don't make all the parties, the partition suit is going to be dismissed. So second, cause of action, क्या था? मैंने उनको partition का notice दिया, उन्होंने फिर भी partition नहीं किया, tick. Jurisdiction, मेरा प्रॉपर्टीज कहां पे है, कॉज ऑफ एक्शन कहां पे है, 16 to 20 of the CPC, tick. So always have this checklist handy for one category of a suit. Partition के लिए अलग से checklist होगा, जैसे Boeing 737 के लिए अलग checklist होगा, सेस्ना के लिए अलग checklist होगा, वैसे ही आपकी सूट के लिए अलग checklist होगा, पार्टीशन के लिए अलग होगा, रिट के लिए अलग होगा. But my advice to the junior lawyers to always have this checklist ready. You will never go wrong. Thank you so much for being here. Thank you so much for the session. Yes, please.
Yeah. Thank you, Yuvraj. As usual, it was so enlightening, especially for not only for a young lawyer, but for all those who are willing to learn. As you just said that just like a pilot, we all have to have a checklist.
Yeah.
Since I come from the defense background, there even while you prepare the food, you have to have a checklist whether everything has been put on the table or not. Yeah. This is so whether Section 91 to 99 of the Indian Evidence Act, exclusion of oral evidence by documentary evidence, also applies to criminal cases.
Absolutely. What I just said applies to everything, applies to the criminal case, except one very important factor which doesn't apply. In the civil trial, unless you examine the author of a document, the document is not proved. In criminal cases, there is section 294 of old CRPC. Please have a look at the BNSS, what is equivalent section. Wahan pe, without calling the author, the document is proved. In the criminal procedure, there is no much importance given to the documentary evidence, because obviously for the reasons you would know, documents do not really matter much in the criminal. Wahan pe, without calling the author, the documents are proved. 294, like the experts, forensic experts' opinion. But rest, all the factors would apply equally to the criminal trial.
In case someone forgets to attach the documents with the written statement, and in the next stage on the filing of the documents, does he require to take a leave for submitting those documents?
Yeah, that's what Order 8, Rule 1A4 says, that unless you submit all of them along with the written statement, you need to take the leave of the court. And you need to state in whose possession and power the document is at the outset. But if you forget doing it, then there is a judgment of the Supreme Court. That citation also I'll share. The Supreme Court had said ultimately justice is not the handmaid of the procedure. You will have to look at the substantive justice. Such applications can be allowed unless it's really putting the case on a back burner. Again, very important fact. Sorry, I forgot mentioning this. This is very crucial. There are certain kind of sections. For example, in the Land Acquisition Act, if you look at, there is a section which says that the certified copy of a sale deed of an adjoining land is a good evidence of its market value. The Land Acquisition Act does not require you to summon the author of the or the party to such sale deed, because the section itself gives the primacy to such evidence. So the Supreme Court has said that in these kind of scenarios, the author need not be called. The document itself is the evidence, and you don't need to have the author examined for these special statutes like Land Acquisition.
As to whether to proving the contents of the documents, must the contentious recitals of the agreement deed mentioned in the evidence on affidavit?
No, this I did not get really. Sorry, it's written there?
Yeah, it is written on the chat. It is.
What is it? To prove the contents of a document, must the contentious recitals of the agreement deed mentioned in the affidavit of evidence of contentious recitals? No. See, I'm not a big fan of reiterating these recitals unless they are really, contentious. I think you mean the material recitals. Yeah, I would always advise, because as Order 7 says that it must contain the material particulars. So yes, it is always advisable to have the contents of the documents, the material contents to be reiterated in the affidavit. Only one thing, sorry, since Mr. Sabha asked about the contents, the judgment of Justice Dhanuka, I'll share that. If the affidavit of evidence and the judgment of Justice Patel of the Banganga, very, very, very enlightening judgment, it says that the affidavit of evidence cannot contain anything irrelevant, anything allegatory, anything in the nature of legal submissions. If it contains, you can move an application for striking off the evidence. Because suppose a person comes in the witness box, he is being orally examined, the old days. when this affidavit business was not there, the court asked a question to itself, will you have allowed this to go in because it's irrelevant? No. Then how can you allow this to pass a muster when it's an affidavit? So the affidavit cannot contain any submissions, the affidavit of evidence. And if you ever find your opponent's affidavit of evidence contains something allegatory submit in the form of legal submissions, क्या होता है बहुत से टाइम प्लेंट का कॉपी पेस्ट होता है एफिडेविट, द लॉयर का लैंग्वेज भी आता है, एलिगेशंस आते हैं, सबमिशंस आते हैं, प्रेयर्स आते हैं, कंटेंशंस आते हैं. Judge had said, sorry, the affidavit cannot contain that evidence must be struck off. So affidavit of evidence, be very careful of putting just the bare facts which suit your case.
This is how can a forged document be proved that it is a forged document, and how can it be exhibited?
No, the forgery obviously will have to be sent to the forensic expert under section 45. And then his evidence will have to be called for. You will have to say that it's a forged document. But let me tell you, if it's a document which extinguishes your title, then the judgment of Anathula Sudhakar, A-N-A-T-H-U-L-A, Anathula Sudhakar, where the Supreme Court has said, if there is a clog or the cloud on your title, just don't call it a forged document. You will have to amend your plaint and seek a declaration that document is forged and does not bind you. For example, in a suit for a partition, if there is a document of a partition deed shown to have executed in the year 1962, to argue that ab kahan ka partition, ye to pehle hi ho chuka hai, then as a plaintiff, you will have to amend your plaint and seek a declaration that the deed of partition is a forged and fabricated and hence does not exist in the eyes of law. If you do not do that, the judgment of Justice Datta is also there, Dipankar Datta, where he had said that unless you impugn such documents by way of amending the plaint, you will not get the principal relief.
That even the Constitution bench says that until unless you even challenge the void order.
Correct.
In the absence, it will be presumed that you are satisfied with that. Because the issue arose as to whether a void order can be challenged at any point of time or not.
Correct. As long as it's holding the field, you cannot label it void in any proceedings. The judicial forum must have declared it to be void.
This is?
Is any court fee required to be affixed on the documents? No. There is no court fee to be on any documents. There is a court fees which is required on the applications, miscellaneous applications, a standard court fee.
This is,
a sense notice to be.
In a criminal case, only documentary evidence is.
Sorry?
I'm not very sure whether it's a question or an answer.
Am I cross-examining it? And I want to confront the witness with the audio recording, video recording, how to do that. No, it's very difficult. Therefore, now I would not personally advise to go for a VC cross-examination because there is also a possibility of prompting a witness from behind the screen. What you can do is to, rather, I'm not answering this question, but I'm just, since you spoke of VC, always ask the witness to roam around in the room with the camera just to see if there is anyone sitting in the room. And always make him sit in a way where the door is behind him. So if you see any person entering, you can see through the door that person is entering. So that's the basic thing you can do for VC. But otherwise, let me tell you, in the international arbitrations, we do it very often. We share the screen, we show it, we have a common compilation ready. There are softwares, very costly softwares which come where the case management teams are sitting there who when मैं अगर कोई question पूछ रहा हूँ तो simultaneously they will project it on a screen. It's done very professionally, but I'm not very sure whether the district courts will have that facility. I would not advise any VC if you have to confront the witness.
The secondary evidence produced of the original is section 65B mandatory.
Is the
in case the secondary evidence is produced of the original, and section 65B mandatory?
No, secondary and 65B does not have really anything to do with each other. 65B is really is a certificate that I will give along with the printout of an email or a WhatsApp chat. And they are generally secondary only, in a sense that my printout to original nahi hoga because the original to computer laptop hai. So it's a print. So it's actually a secondary. But it's not a secondary, it's a third category of an electronic evidence. The Evidence Act has got 4 categories: primary, secondary, electronic, and ancient documents. Primary to 60 जो है, जो हमने बोला, secondary जो हमने बोला. Electronic is this separate category, section 63 of BSA. And fourth is the ancient documents more than 30 years of age, which enjoys the presumption of genuineness, except the will. So this third category is what you are talking of. So for electronic evidence, there is nothing secondary and all. It's always the secondary. But it is not called a secondary, it's called as electronic evidence if it is accompanied by the 65B certificate.
These were the questions. And like we had discussed, could you just sum it up in Hindi if your throat permits for around 5 to 10 minutes? Yeah. Yuvraj ji,
Yeah.
summary in Hindi.
Oh, sorry, I forgot that. No, it's frankly Hindi. That's my problem in that.
You can do it in
Yeah, no, see, basically, जो हमने बात किया यही था.
What can be done is you can do it in a Hindi-English mix.
No, in a minute I'll just try to summarize it. यही है कि जब भी आप कोई भी केस के लिए जाओगे तो always have a checklist handy. Don't at all go by the client's instruction. आपको एक जो मैंने शुरुआत में आपको जो स्क्रीनशॉट दिखाया था, आप उसका स्क्रीनशॉट लीजिए, आप अपना खुद का चेकलिस्ट डेवलप करिए. आपको जो स्टेज पे जो ऑब्जेक्शन लेना है, अगर आपने वो स्टेज मिस कर लिया तो आपको बाद में वो ऑब्जेक्शन लेना डिफिकल्ट होगा या नामुमकिन होगा. तो आपको जो भी करना है, आपको वही रादर एग्जैक्टली वो स्टेज पे करना है. जो जजमेंट्स मैंने आपको बताया आज के दौरान, यू हैव अ लुक एट दो जजमेंट्स. वो जजमेंट्स आपको बताएंगे कि कौन सा ऑब्जेक्शन आप कौन से स्टेज पे ले सकते हैं. अगर आपने वो स्टेज क्रॉस कर लिया, देन यू कॅनॉट टेक दोज ऑब्जेक्शन्स. मराठीमध्ये हेच आहे की बेसिकली तुम्ही करत असताना फक्त एवढंच लक्षात ठेवा की आपल्याला शेवटी कुठं जायचंय, माझा एंड काय आहे, मला नक्की काय अचीव्ह करायचंय. जर तुम्ही तुमचा एंड डिफाईन केला तर तिकडे जायचे मार्ग अनेक असू शकतात. जर कदाचित एक मार्ग बंद झाला असेल, फॉर एक्झाम्पल तुमचं सेल कुठला तरी क्लायंट आला आणि म्हटलं माझ्याकडे सेल डीड साहेब नाहीच आहे, माझ्याकडनं हरवलंय ते सेल डीड. तुम्ही म्हणणार अरे मग मी स्पेसिफिक परफॉर्मन्सचा दावा कसा करू. It's not difficult. Look at the definition of secondary evidence. Oral account of a document by the person who has seen the document is also a secondary evidence. जर तुम्ही प्लेंट मध्ये हे म्हणू शकला की माझा ओरिजिनल अशा दिवशी आगीत जळाला, पण तो जळायच्या आधी ह्या व्यक्तीनं पाहिलेला होता, तर त्या व्यक्तीचा पुरावा हा सुद्धा सेकंडरी एव्हिडन्स आहे. त्याच्यावर अख्खाच्या अख्खा सूट डिग्री होऊ शकतो. म्हणून तुमच्याकडं काय आहे आणि तुम्हाला काय हवंय या दोन्हीचं जर भान ठेवलं तर मधल्या या सगळ्या मिसिंग लिंक्स तुम्हाला एव्हिडन्स ऍक्टनं भरून काढता येतात. सो दॅट्स इट विकासजी, माय शॉर्ट समरी फॉर टुडेज लेक्चर इन दीज टू लँग्वेजेस. थँक्यू. Okay, so I think we can log off, Vikashji. Anything else? Unless there are any questions, I think we can log off. I can't say Vikashji. Yeah.
Some people are asking about the citation books. We'll ask Yuvraj to share this thing and we'll post it on the website of Beyond Law CLC.
Sure. I'll do that.
Thank you, everyone. Stay safe.
Thank you. Thank you so much. Thank you.
Tomorrow's session would be on the overview of the Domestic Violence Act. Do join us tomorrow at 6 p.m. Everyone's enjoy your weekend. Thank you.